Very good, hearty good evening to all of you. I hope you are enjoying the best of your health and everything is going great at your end. Uh, Things are becoming quite, we can say, unpredictable because the way Corona is growing. And I hope that you people are taking all the needful precautions which are required to be taken. Here also, we are observing all types of precautions and staying in the campus or staying on the campus is quite difficult when people are less. And this is the first time experience what I can say that not everyone is there. Majority of the teachers have already left. Also, making the lectures and preparing the lectures and coming. Um, it's the first time experience that we all are undergoing. You are at the other end listening and watching the lectures and are we just preparing the lectures without even able to see your expressions, your you can say what you are having your facial expressions. Okay, eye contact, all those things are missing. So crisis is every crisis is an opportunity, and this crisis also is an opportunity for us. And we have, if not, we have to create one because we just can't wait for the things to get normal. And we don't know also whether things will get normal. The time when the vaccine will be available in the market, or before it, or after it, we don't know anything. So this is, we can say, a part of life, and we have to live accordingly. There is no excuse for us to skip our work and to make or take the things easy because whatever we are facing, it is we face by all the people living across the globe. It is not new and it is a very chaotic condition and we doesn't know what consequence or what will be the output of this particular, we can say, pandemic. It is very sad to hear regarding the economy and we can just hope for the better. Okay, so coming again to a subject we started in the last class, we started the alienation of co-pastory property. And while we have studied, we started the alienation of the co-pastory property. In the last class, students we have seen that who may alienate the co-pastory property, which means that who is having the right to alienate the co-pastory property. Alienation by sole surviving co-pastor, which we have to see, and also we have seen the alienation by father and manager of co-pastory property. Rather, we started the Karta's part of alienation in the last class. I suppose that you are things are the PPT is visible to you and you are able to see it. When we talk about the Karta's part of alienation, we have already discussed in detail. We have already seen, and we can say that Karta's part of alienation has been segregated into three, we can say, uh, different uh, categories. The very first is the legal necessity, second is the benefit of the state, and the third is the indispensable duties. So yesterday we started with legal necessity, and in legal necessity we have discussed in length. This is the second time we are discussing, and this time we have seen the term, the concept of legal necessity, with the help of case laws. And in the last class, we have discussed the ample number of cases by which we came to know that what has been propounded, what principles and findings came out, and what was the decision of the apex court. So we can say that it is something which is a judge made, or it is dependent upon the judicial pronouncements, and it is totally something which is having a judicial activism. So this is true that law transforms the society, and we are seeing that the legal organ, one of the legal organs of law, is judiciary. How judiciary is trying to interpret the law and create a sort of a criteria benchmark by which we may judge, or by which we may know what is meant by the term legal necessity or benefit of the state, or further we can say the indispensable duties. So in the last class in length we have discussed regarding the concept of legal necessity, and we have seen the Karta's power, and what are the consequences of the power of the karta, or the we can say the work of the karta, and what consequences it carry to any contract, or what agreement to any agreement. We have also seen about Section 6, which talks about the Hindu Succession Act, and there was an important thing which we discussed, that under Section 6, now a female, no female property can be, you can say, alienated, or any treatment may be made without her consent, because Section 6 is very much complying with the rights of a female. Further, we have studied many case laws. Also, one of the case law which we have seen was Ram Vilas versus Ramanand, in which we have seen the term is to be, or the term of legal necessity should be interpreted with due regard to the condition of modern life. Because what modern life is, and what we are living in at this particular situation, the term necessity has changed a lot. Maybe we can say that there were certain things which were not so peculiar in the ancient past, but right now they have become a necessity. And the education, we can say, has become a necessity. Earlier, when India got her independence, the literacy rate was very slow. It was something 14%, to my knowledge, to my limited knowledge, I should admit it. Right now, we are having a good, we can say we have improved a lot. So we can say that education is a sort of a legal necessity right now, as discussed in the case of uh, Ram Vilas versus Ramanand. Also, we have seen that there is no possibility to enumerate the cases of legal necessity, and cannot be exhaustive. There is no, we can say, strict formulae by which we can get we can derive what is meant by the term legal necessity. Because what is legal necessity? What does it connotes? It is having a very we can say wide connotation. It is having a very wide interpretation, and therefore it remains to the court to decide what is meant by the term legal necessity. Students, further, we have seen the Madras High Court has took the view that a second marriage is not a legal necessity. And if you are able to see or remember the last case which we have seen, Patel versus Lucky Reddy. And in this particular case, it was held that the second marriage is not a legal necessity. So which means that the first marriage is a legal necessity. Okay, apart from that, we have seen different, we can say, we have classified legal necessity into many classes. For example, the payment of debts, and the payment of government dues and taxes and revenue. Also, what we have seen, we have tried to analyze that whenever the defense of a member who is involved in a criminal charge, may not, we can say, but not for prosecution of a person accused of murdering a family member. So that is not a legal necessity within the scope of legal necessity as held by the courts. Also, I told you that we can have ample of legal necessities and so on, no issue. Right now, a short-term objective, a short-term goal is to clarify the exam. There may be that there are so many cases under the concept of power of Karta's power of alienation that you can write a dissertation. But the objective, the short-term objective is to clear the exam, which is very basic. So for the purpose of exam, we have done enough. We have seen enough with regards to the term legal necessity. And when you maybe there is a chance that you may go for litigation, some may join the bar, whatever. So it is your, we can say, I can say it is your effort. It would be your effort to recognize the same if any dispute, if any issue comes to you. Okay, now I would like to move to the next slide. And this next slide, this particular slide is talking about the benefit of state. When we talk about broadly speaking, the benefit of state means anything that is done with the which will benefit the joint family property, which will you can say benefit, which will give an advantage to the joint family property. So Privy Council in the case of Palinappa versus Davis Devsik Moni. In this particular case, Privy Council observed that it is impossible to give a precise definition of its applicability in all cases, and they do not attempt to do so. The preservation, however, of the state from extinction, the defense against hostile litigation affecting it, the protection of it or its portion from injury or retortion by intuition, these and such like things will obviously be benefits. So whatever tries to destroy, damage, defraud the property would be considered as something, and any amount of money which is we can say is used to stop all those things will come or fall under the category of preservation. And preservation of the state from extinction means benefit of the state. This was held in this particular case of Palini Appa versus Devsik Moni. Further, what we have seen that following this particular decision, the High Court took a divergent view, and we can say a sort of a different view. According to one view, they only that they, we can say they that will be the benefit of a state which is not of a defensive character, which is done to avert an imminent danger to the property, repair of a house in a dilapidated condition, construction of dikes and bunds to prevent flooding of land or defense of property, which we can say that involved in hostile litigation, and such and the likes acts alone will amount to benefit of state of litigation. Such and the like act will amount to the benefit of state. Accordingly, we can say anything done merely to improve the property will not amount to the benefit of state. Okay, so again, in the full bench, in the case of Jagat Narayan versus Mathura Das. In the case of Jagat Narayan versus Mathura Das, the Allahabad High Court has held that and has overruled the full bench judgment. And according to this particular case, anything which is being done just to improve the condition of property would not amount to benefit of state. The benefit of state, which we can say that, as I told you, which is done for the which is done to prevent the state. It is a sort of an act which we can say is done to preserve the state from extinction. So whenever we are trying to preserve anything from extinction, that particular thing is something which is coming to the benefit of state and not merely to improve the property. So again, there are different views as we are dealing with the subject. It is very much subjective. So in the case of Hemraj versus Nathu, the second view we can say that is that anything done which is of positive benefit to the state would amount to the benefit of the state. So positive benefit, negative benefit, the courts are free to interpret the law as they wish. Okay. So now the again a new word or new you can say terminology was coined known as positive benefit. And the test of we can say positive benefit is something which is prudent, and a prudent person can do in respect of his own property, and karta can do in respect of the joint family property. So these are the things which we have seen in detail, we have discussed in detail in a we can say previous class also when we have done the powers of karta. Now we are seeing the benefit of state, and now we are seeing benefit of state under the title of the power of alienation of karta. Okay, this is the only difference. So what happened in the case of Hemraj versus Nathu, that there was an intermediate view that the property cannot be alienated merely for the purpose of enhancing its value. Okay, though at the same time it would not be correct to say that no transaction can be for the benefit of the state which is not of a defensive character. So the judicial opinion has come in favor of the test of a prudent person. The karta is assumed to be a prudent manager, and therefore he can do all those things which are in furtherance of the family's advancement, or to prevent a probable losses if it is provided under this act, and not purely of a we can say of a speculative or visionary character. Whatever acts are done, they should not rely on any speculation or should not have any visionary character in front of it. Or which what does it mean? That it simply means that Karta is has drawn a sort of an hypothesis, or Karta is having a presumption, or Karta is has anticipated, forecasted that this may amount to the we can say a loss which will further destroy the property, laws which may further because of which the property may get extended. So therefore, to complete the lines, to complete the you can say statement, we can further say that whatever the karta is doing, he has to justify it. It should not be something which is very speculative in nature, or rather, it is very he's having some sort of visionary, or we can say some sort of reflections or what. This particular thing was also discussed in the case of Nirmal versus Satnam. In the case of Nirmal versus Satnam. So whatever Mr. Karta is doing, he is supposed to rely on, and Mr. Karta needs to justify it instead of being speculative or having a visionary, we can say some sort of vision by which he is afraid that or frightened that the property may get destroyed. So this implies that the Karta cannot convert family property into money just because the property does not yield any income without replacing it with some other more advantageous property. So it is not that the Mr. Karta may just try to sell the property. Mr. Karta may just try to exchange it or convert it to make money. So this is not a practice which comes under the category of benefit of state. Whenever we are talking about benefit of state, by the term itself, benefit of state, it means that whatever is being done to the property, it should be done to preserve the property, and not to we can say to convert the family property because the family property is not giving any return or money, and just because we are Karta is trying to replace it, it will become a more advantageous property. It is not so. Okay, so this particular thing was again discussed in the case of Ramnath versus Guru Gurantiyal. Ramnath case, you can say in the case of Ramnath versus Gurantiyal. So in this particular case, it was held that whenever he's doing any act, It should not be something done just for the advantageous purpose, by which the property will become an advantageous property. No, it is not so. So these are the ample of cases by which we can understand, and from the examination point of view, they are sufficient for you. But to justify the particular topic, I have to deal with different cases again. So the Karta's power to constrain to purely defensive acts. But when we talk about that if Karta's power is to constrain to a purely defensive act, there would no progress. The enterprise would stifle and the family would get stagnate. The sale of a dilapidated house, the sale proceeds of which were utilized in constructing a second story on the joint family is proper as one for the legal necessity for the benefit of the state. So there are different views, there are contradictory views, and many a times what happened, the purely defensive act, we can say, are inferred as something by which the family progress, by which we can say, if not done, the family would get stagnate. So they become the part of benefit of state. So it depends upon the, we can say, upon the bench, also upon the presentation by the lawyer. There are so many, we can say, so many dimensions are this particular thing is having, and there are so many factors which further affect the judgment. So further, when we talk about the sale of property to enable the members to migrate to another place, also to purchase more productive lands, where there we can say, which we have already discussed. If you are able to recall that particular thing, which we have seen in a last, we can say, case, where we have seen, if I'm able to recall, Justice Madhulokar, and he also said the same thing. For a transaction what to be regarded as a benefit of the family, it need not be defensive character as to be binding on the family. Okay, so whenever we're talking about that, that it is of something which is there, and this particular transaction to be regarded as a benefit to the family, it need not be a defensive character so as to be binding on the family. Okay, in each case, the court must be satisfied from the material before it that it was in fact such and conferred or was reasonably expected to confer benefit of the family at the time it was entered into. So it depends upon the court also, and when the karta who was running a hotel business, suppose, and mortgaged the family property with a view to for raising funds out of those, we can say, mortgage for renovation and reconstruction of the hotel. It was held to be a, we can say, something for the benefit of the state. So benefit of the state, when we talk about, we have to underline, or we have to keep in mind that particular principle which I discussed to you, and according to which all the acts which are done merely for the preservation of the state, and if it's not done, the extension of the state will occur. The state may extend, it may get destroyed. So this is the basic principle. And in ample number of cases, the courts have just whatever they have inferred by this particular principle itself. There is no other principle. Okay. So this is what meant by the term, we can say, the benefit of state, and it is having many dimensions. It is interpreted with what I can tell you with different, we can say, colors. Okay, many a times the court allow, and many a times the court become rigid. So similarly, we can say the land yielding no profit if that particular land is sold to purchase land yielding profit, it was held to amount to the benefit of state. So again, we are seeing that how the judgment get reversed, and this is no new. You people, I suppose, are going studying constitutional law. Under constitutional law, also we have seen that in ample number of cases. For example, in one case, it was held that preamble is not a part of the constitution in the very case. And again, in Golaknath case, it was held that The preamble is the part of the constitution. So it depends upon the bench. It depends upon the judges. Judges are having their own perception. Perception means their outlook. And this particular perception, whatever the judges are having, is solely based on their, we can say, the environment in which they were brought up, and their education and other factors are there. So there is a possibility that a particular judge will have a particular bent of mind. Somehow we just can't bring the computers or robots to get a decision done. So that's why we have to bear for it. And also, what happens many a times as a student of law, you have to understand as that the untrained mind jumps to conclusion very fast. Whenever there is an untrained mind, the untrained mind make draw a conclusion very fast, and which is not good for a student of law. We as a student of law, we have to see all the steps before we conclude anything. That's why it is said that one of the principles of the natural justice is to hear the other party also. The other party should be heard before the judge pronounce the judgment, because there may be a possibility that whatever seems to us that it is not coming under the benefit of the state will be an act which is directly, we can say, affecting. It is something which is directly related to the property, and hence it is a benefit of the state. So there are so many things, and we are just trying to analyze the findings of the cases. We are not in a position to go and check the facts of the cases, because when we try to draw the facts, it will take time, and that is also not an exercise, because for that particular purpose we are having the moods which you people submit, and then you argue on that particular line of, you can say, argument. Here we are trying to see the findings which supports a concept and which further clarifies the concept. Okay, so where the entire homestead land was sold for the purpose of buying another piece of land for construction of a residential house, the sale could not be considered to be an act of prudent management for the benefit of state or legal necessity. Because you are just selling your house, and what is the purpose of constructing a residential house, and that is not something which may come under the benefit of the state, and therefore it won't suffice as a sort of a defensive act by which the Karta will take a defense that this is something which is done for the benefit of state. So the other co-partners may object to it. There are the co-partners who are living in the same under the same roof, but they are not allowed to the new residential house. So they may object that our property, our, we can say, heritage has been we can say, alienated without a justifiable cause, without a justified cause, and hence it is not a thing which should come under the, we can say, under the exceptions, or under a particular we can say power of karta, or under any legal necessity. So these are the ways by which the court draw the inference. Okay, so we have seen right now the benefit of state, and we have tried to analyze the things which are very necessary for the preservation of any state from getting the state getting extinct, and the defenses are there, and whatever defenses are there, it is for the protection and of the property from getting injured or destroyed or by any invasion, and these things are obviously done with a view of protecting the property, and which is known as a benefit of the state. So in the last class we have seen the legal necessity, and in this class we have seen the what we can call as a benefit of state. So I will like to I will like to rather revise the same thing what Vijayaneshwara has said. I would like to connect what we have seen in the last class already. Vijayaneshwara confirmed this power on every member. When Vijayaneshwara, if you are able to recall, was able to confer this power to every member of the family. So there was a hue and cry at that particular point of time, because the formulation which Vijayaneshwara has conferred has undergone a modification, And I told you that there are certain modifications. First, the power which we have seen cannot be exercised um, by any member except the karta, and secondly, the joint family can be alienated for the following purpose. And there were three purposes which we have studied in the last class. The very first purpose was the legal necessity, and the second purpose was the benefit of state, and the third was the acts of indispensable duty. So we have seen that it is now well settled that the karta can alienate the joint family property with the consent of co-partners, even if none of the, we can say, the conditions which we have discussed are fulfilled. So if all the co-partners are adults, then it is binding on the entire family. So this was something by which we have started our lecture in the last class. Now we will be continuing the lecture, and we may be discussing the concept of indispensable duties. The term, when we talk about indispensable duties, are something which are a sort of, we can say, performance of certain acts, okay, which are religious, pious, or charitable. The acts which are somewhere related with the religion and piousness, okay, and also are having a character of charity. So these acts are, we can say, are termed to as an indispensable duties. Further, the commenter Vijayaneshwara on instance, he has he has said that the obsequies of father, and further he added that it is clear that the expression includes all other indispensable duties. It is not something which is confined to these particular things also, but also we can say the performance of marriage. In Hinduism, we see that it is known as a sanskara. Also, we know that it is a part of a religion which is may be called as a dharma. Dharma means a duty. So these are the instances in which we can add things to the indispensable duties. Again, I would like to tell you that it is not an exhaustive term by which we can write down or pen down and we can complete it. No, because the world is getting evolved, and due to the evolution, there are instances which may be totally new to the court also interpret, and therefore we can say that the performance of marriage, as we have discussed right now, of the members of the joint family, particularly of daughters, okay, is an indispensable duty, though it is also covered under the legal necessity. So it is not that these particular these particular exceptions, the powers of the karta of alienation, are divided into a watertight compartment. No, they are free to get mixed, and there is no such rigid separation. We have just tried to formulate three basic, we can say, heads, and under which we try to classify the events and things. Okay, so in the case of Vikuntam versus Kala Piran. In this particular case, it was held that the ceremonies such as, we can say, there are many ceremonies like Gona and other thing also, and which are done, which by which the marriage get completed, are also the part of indispensable duties. So there are many things which have been discussed, or there are many things which by which a ceremony of marriage completes. So all those ceremonies of Bona and Ritu Santi, and we can say also there is one which is known as Graha Pravesham. These are the we can say Sanskrit words, and they are more popular in Hindi belt. So Graha Pravesham is something when the couple or the bride enters into a place, and Gona is something which is done during the marriage. So according to the Vikuntam versus Kalapiran case, these particular acts uh, were also classified as something which are indispensable duties. Further, we can say that apart from such indispensable ceremonies, gift within a reasonable limit can be made for a purpose. Okay, so there is no such thing. A small amount of gift can also be given under the head of indispensable duties. Okay, in the case of Churamam versus Gopi, in this particular case, uh, it was held that a small portion of property can be alienated for a family idol or to an idol in a public temple. So whenever you are there, as I told you, this particular indispensable duties applies to the performance of those acts which covers, or rather which are religious, of religious nature, or of charitable nature or pious nature. So in this case of, we can say, Churampam versus Gopi, it was held that it was said that whatever a small portion is given from the property, a small portion of the property can be alienated can be alienated for a family idol or a temple's idol. So this was held in this particular case. Again, we can say that there is another case known as Karan versus Surendra. Okay, this particular case is there, Karan versus Surendra, which we will be discussing. But before we discuss the case of Karan versus Surendra, we have to understand the case of the other case. In this case of Karan versus Surendra, the property which was the amount of money which was given as an alienation for a temple was also held to be an indispensable duty or something which is following under the category of indispensable duty. So there is another case. The name of the case is Gangi versus Tamu. Writing here. Gangi versus Tamu. In this particular case, also, the Privy Council held that the dedication of a portion of the family property for the purpose of a religious charity may validly be made by the Karta. The Karta is having the power for the dedication of a portion of the family property for a purpose of religious nature, okay, or religious charity. If the property allotted is small as compared with the total needs of the family, such an alienation cannot be made by a will. So we have seen that there is a distinction between the alienation made in the discharge of indispensable duties, okay, and gift of small portions of joint family property made by the karta for a charitable or a pious purpose. So these are the things we can say that in many cases the karta's powers are unlimited, and he may alienate the entire property. In the latter cases which we have discussed, he can alienate only a small portion of the joint family property, whether movable or immovable. So karta's part in many cases has been we can say lessened down. They have been brought down. In many cases, the karta's part has been extended. So these are the ways by which the karta can alienate the property under the head of indispensable duties. Okay, so I would like to take a minute for a short break to have some water. So we have discussed in length, we have seen the term indispensable duties, and again, what we have seen that the honorable courts have interpreted the term accordingly. Now coming to the next topic, which is burden of proof. So it is an established rule, we can say, established rule, in a sense that the burden of proof, whether the transaction is for legal necessity or for the benefit of the state, or for indispensable duty, whatever the case may be, is on the alienee. And as the Privy Council has propounded a certain proposition, it is a very old case of Hanuman Prasad versus Babu. Okay, in the case of Hanuman Prasad versus Babu, BABO and ONEE. So in this particular case, the Privy Council has discussed certain principles to establish the rule, to discuss the things uh, regarding the burden of proof, whether transaction is of legal necessity, benefit, or for indispensable duty. It is on the alienee, and the court have tried to analyze this particular concept. There is a call. Okay, so we were discussing the case of what is meant by the term burden of proof, and in the case of Hanuman Prasad versus Babu, is an old case, and in this particular case, the Privy Council tried to propound certain principles, and it was held that the burden of proof lies upon alienee. Alienee is a person to whom the property is being transferred. Okay, so he has to prove that whatever act was done is for legal necessity or for indispensable duty. So the Privy Council has propounded few principles regarding burden of proof in the year we can say that 1856, and further when we talk about the powers of the Karta under Hindu law are limited. It was held in this case, the powers of the Karta under Hindu law are limited and qualified powers. He can exercise the power of alienation in limited cases, such as for legal necessity and for benefit of the state. So the very first thing which was held that the powers of Karta are limited in Hanuman Prasad versus Babu. So in this particular case, we came to know that the very first thing is that the burden of proof to prove that the act which has been done is of a legal necessity, nature of a legal necessity or of indispensable duty lies on alienee. Number one. Number two point we can say, second thing which was discussed in this case, it was the powers of the Karta are limited. Okay, under Hindu law, and he can exercise the power of alienation in limited cases, such as for legal necessity or for benefit of state. And if suppose the Karta makes an alienation, Mr. Karta makes an alienation as a prudent man, as a wise man, in order to the benefit of the state or for the family or for any bona fide lender or alienee is not affected by the previous mismanagement of the state, and provided that the lender or alienee was not party to the mismanagement. In what we can say that the lender or alienee should not have acted malefied, which means that if suppose the alienee or the lender are benefiting from it, so they should not be in a position, and whatever mismanagement has occurred were not committed by them, and somewhere they have not acted malefied. Also, the alienee is bound to make proper and bona fide inquiries as to the existence of legal necessity. Whenever there is a legal necessity, the alienee requires to make certain, we can say, certain proper inquiries to know that whatever has been done is for legal necessity. Also, it was held in this particular case that if the alienee, if the Mr. Alienee is there and acts bona fide and makes proper inquiries, the real existence of an alleged sufficient, we can say, and reasonably credit necessity is not a condition precedent of the validity of alienation. Also, it was held in this case, the alienee is not bound to see the actual application of the money for the legal necessity. So it is the alienee should not be in any sense regarding the money, what transfer has been made, and validation. He should be try to see and act bona fide and make proper inquiries for the real existence of the alleged sufficient and reasonably credited necessity. So, in other words, we can say whenever an alienation is challenged, it is for the alienee to show that there was a legal necessity. It is because when one deals with a person with whom one know is supposed to know to be a person of qualified past, it is one's duty to satisfy oneself that such a person has power to make the proposed alienation. This is very important. It is very something which is having its we can say its roots there, and therefore, however, when the alienee we can further conclude that whenever a alienee is required to prove uh, that either as to the existence of the need and he acted or she acted honestly, if he does so, he has discharged his burden. So his burden of proof has shifted when it is proved that he has acted honestly, and there is no such thing by which we can say he has done in a malified bent of mind. It is immaterial if it turns out that actually there was no need for alienation. Okay, if he does so, he has completed his task, and it is not the duty to see to see the money of applied to the legal necessity. So it is for the administration of the fund and not the trustee. The owners may be discharged, and so he will get released. So students, we have tried to see regarding today, we have tried to realize different aspects of indispensable duties, and we have seen in length regarding the benefit of state and the case laws which are related with the benefit of state. Now, after that, we have discussed in length regarding the indispensable duties, what is meant by the term indispensable duties, and how this particular term indispensable duty has to be defined, whether it is an act which is somewhere related with the religious, the pious, or with an act of charity. And further, we have discussed with the help of few case laws that what is meant by the term indispensable duties and what are those small gifts, whether they form or they come under the ambit of indispensable duties or not. Also, when we have seen the burden of proof Hanuman Prasad case versus Babu, in this case, we have tried to analyze the old case of Privy Council, and in this case, we have seen that it is the alienee who the burden of proof on whom it is there, and he has to prove it. The transaction which has been made, the transaction which has been made are for us legal necessity or for we can say for a benefit of state or for any other purpose. So, and we have seen that in this particular case itself that the powers of the karta are very limited, and also we have seen that the alienee who is there, he or she should not rather it was he at that particular point of time has not acted malified. He has done his we can say the required inquiries has been made that whatever a relation was being made was for a genuine purpose which is supported by the law. Also, we have seen that the alienee acts bona fide than the existence of alleged sufficient and reasonably credited necessary, not a condition precedent to the validity of the alienation. So these are the things which we have discussed, and also we have seen the alienee is not bound to see the actual application of money of the money for a legal necessity, which were discussed in the case of Hanuman Prasad Babu. So till this particular point of we can say to this particular point we have tried to analyze the different dimensions of the term indispensable duties. Also, as time is running short, it is already the recording is telling me it is 50 minutes is after a few seconds will be completed 50 minutes. So I would like to end up here, and in the next class we may start with this particular concept, and we may proceed to the co-parsonary alienation, and then we will complete it. I hope that you people are revising the things which we have studied in the last class. When the Transfer of Property Act applies, the Transfer of Property Act applies in those certain situations where, number one, the property is a separate property and it is not a joint property. So these are the basic things which you should know, and the things which you are able to see on your screen, the PPT which is there, how these particular alienation of the property are being made, and these are the alienation which are made of a joint family property. So this should be clear to you. I hope everything is great at your end, and further, I thank you for your patient listening and watching the lecture. Okay, I may continue the next class. Thank you.